leadership and away from deception. So as news broke of Phala Phala theft, there was only one way to describe South Africa's response, and that was disappointment. Dearly wanting to believe in the new dawn, some clung to the hope that the president has done nothing wrong. Thus, a second wave of disappointment washed over our country 2 weeks ago as the report of Section 89 panel found that the president indeed has a case to answer. The IFP has considered the report of the independent panel, and we believe that it could not have come to any other conclusion based on the information before it. We therefore support the recommendations of the report as the IFP. We wish to thank our former Chief Justice Stanley Ngcobo and the panel he led for performing a very difficult task objectively and giving due care for our country. This panel was established through the Parliament to determine where there was prima facie evidence that the President indeed has a case to answer. Thus, Parliament should set in motion the process of an impeachment committee. Regardless of whatever this right course of action will be defeated by the President's party, regardless of the outcome of the next process, something has broken that cannot be fixed. South Africa cannot trust the President anymore. Worse to this is that this trust was not only to the President, but to the present promise of a new dawn, promising honest leadership. Now we're left asking, is there any among them that is beyond reproach? The temptation is to say, bear the devil you know than the devil you don't. Because for us, President Cyril Ramaphosa was the only hope we had in the ANC. He stood against the factions that fought to impose radical economic transformation at any cost, and in fact, at the cost of our ailing economy. If the President is not exonerated, we fear what will come next. Looking at the possible outcome, it is clear that we should expect the worst. The IFP has deep concern for our country. It is patently clear that there are no longer leaders in the ANC whom we can trust. For what was once a glorious liberation movement has become a morass of moral corruption. I know the pain the IFP founder has, who once served this greatest liberation movement until it abandoned its founding principle. It has placed its cause on a path of a terrible destination, and tragically speaking, that destination has been reached. Whatever becomes of the latest stain in the ruling party, we, the people of this country, have been betrayed. The IFP support the report. Thank you.
I thank you, Honourable Member. Thank you. I now invite the Honourable Dr. P.J. Groenewald.
Geachte Speaker, on the 9th of June this year, we had a debate on the Phala Phala issue in this House. Yes, we did. And my advice to the Honourable President was to come and take the public in his confidence and give the answers. Because the President is on record where he said that he did nothing wrong, that he didn't break any law. So then it is just common sense that if you have nothing to hide, that you will come forward and take the people of South Africa in your confidence and give the answers. But again, the President decided differently. Now, firstly, there's no doubt that in this whole issue, the decision of the President is not in the best interest of South Africa, but only in the best interest of himself and in the best interest of the ANC. In terms of Section 83 of the Constitution, it says quite clearly that the President must uphold, defend, and respect the Constitution of South Africa. Now, Honourable Speaker, if the President had respect for the Constitution, he will avail himself to be accountable to the National Assembly. If we go and see what the Zondo Commission found, it was clearly stated that the President himself didn't take enough steps to ensure accountability. The former speaker apologized to the people of South Africa, saying that they failed to hold the executive accountable. Now, Chairperson, if the President respects the Constitution, he will come forward and then answer to this House to ensure accountability. And why do I say it's common sense? Yes, you can go to all the courts, you can go to the Constitutional Court, but it is a fact that the President himself said that there was foreign money at his farm. Whether it's $580,000, whether it's $1 million, whether it's 100,000 is irrelevant. The fact is that he admitted an amount in foreign currency. Now, Honourable Chair or Speaker, it's common sense to ask them, well, did you comply to the regulations to declare it? It is common sense to ask, if you want to say it's a company, did you pay VAT, for instance? It is common sense to ask, why did you wait so long? It is common sense to say, well, why did you stuck them in furniture? Those are common sense. And Honourable Chair, what the people of South Africa wants is answers to those common sense questions. En die feit dat die agbare president dit nie doen nie, skop hy eintlik die mense van Suid-Afrika in die tande en sê, ek is die president, ek is nie verantwoordbaar aan julle nie, en buitendien is die ANC se belang baie, baie belangriker as die belang van Suid-Afrika. Ons sal wel hierdie verslag aanvaar. Dankie.
I thank you, Honourable Member. I now invite the Honourable Reverend Mishwe.
Thank you, Honourable Speaker. I stand here on behalf of the ACDP to support the report of the Section 89 Independent Panel and its recommendations. On the 9th of December 2022, I wrote a letter to the Speaker of the National Assembly requesting her to review her decision to apply an open voting procedure for today's crucial consideration of the panel's report. On the 11th of December, the ACDP's Deputy President, Honourable Wayne Thring, again petitioned the Speaker to allow members a secret ballot for this debate. Both requests were declined. Honourable Thring's petition to the Speaker was made after an article appeared in the Sunday World on the 11th of December, in which Honourable Mantashe was reported to have told ANC members to, and I quote, toe the line or leave the ANC, close quote. And the ACDP believes this reported threat by the ANC's chairperson will prevent ANC MPs, in particular, from holding the executive to account and upholding their oath to, and again I quote, perform my functions as a member of the National Assembly to the best of my ability, close quote. It is disappointing, Speaker, that a request for a secret ballot for today's debate was not granted because evidence suggests that some members of the ANC supported the panel's report but were strong-armed into voting their conscience for fear of losing their jobs. Speaker, even if the ANC bullies their members into voting against this report, the matter will not end here. The ACDP believes that President Ramaphosa has a case to answer. He is yet to tell this House how millions of dollars came to be at his Palapala farm and why he did not declare them to SARS, the Reserve Bank, and other financial regulatory bodies as required by law. He must still explain why the theft of that money was not reported to the police, and he must shed some light on who the Sudanese businessman, Mr. Mustafa Mohammed Ibrahim Hazim is. Is it true that Mr. Hazim carried the sum of US dollars to the value of 580,000 in cash to the president's farm? And if so, was that forex declared at immigration when he entered South Africa? The ACDP calls on President Ramaphosa to stop being evasive and be honest with the people of South Africa by answering the many unanswered questions. We further call on all members of this House, particularly the ANC members, to vote today for accountability, transparency, and according to their conscience, without fear or favor. Thank you.
I thank you, Honorable Member. I now invite Honorable Olomisa.
Honorable ANC Speaker, Deputy President and members.
Honorable General.
Okay. Tata Mama.
Okay, I'm not an ANC speaker.
Are you a member of ANC?
I am a member, yes, you're right.
All right.
But I am not a speaker of the ANC.
Stop.
I am your speaker, by the way. Order.
The United Democratic Movement supports the Section 89 parliamentary inquiry. When the Section 89 independent panel was given the mandate to look into these allegations, we were all on board, and we must now let the entire process run its course. We make this point mindful of the fact that the panel, by its nature, did not have the capacity to call for witnesses. The UDM therefore believes the four main players in the case, like President Ramaphosa, Arthur Fraser, Benjamin Chauke, and Hazim Mustafa, must be given the opportunity to give their side of the story. However, let us not forget what is at the crux of this matter. The fact that there was a large amount of foreign currency hidden in President's furniture and how this cash crossed the country's borders. You will recall that the UDM made a submission to the panel detailing how Mr. Chauke, an advisor to the President, flew in and out of the country to facilitate the movement of illegal funds. It is not sufficient explanation and defense for Hazim Mustafa to purport to have declared 600,000 US dollars to customs, which falls under SARS. The South African Reserve Bank would need to have first duly approved the inflow of that amount of US dollars and require such to have been banked in any SARB licensed forex dealers and agents. In conclusion, the Section 89 panel has found that the President has a case to answer. Let there now be a full inquiry by Parliament, the very institution that elected him to office, and to which he is constitutionally accountable. Sithi mawubuye uMzantsi Afrika esiwuthandayo emaseleni mawubuye.
I thank you, Honorable Member. I now give the floor to Honorable Zungula.
Mandibulele Speaker. I thought uzonikeza ixesha elininzi kodwa masiqhube. Speaker, this is a watershed moment in our Parliament. Parliament today will either affirm that no one is above the law or some people are above the law. It would be a travesty of justice if Parliament takes a resolution that the President should not be given an opportunity to clear his name with such serious allegations hanging over his head. It is only Parliament that is empowered to investigate the constitutional breaches and acts of misconduct of the President. The Parliament cannot be told to wait for the investigations of the Hawks, NPA, Reserve Bank and SARS. The heads of these institutions are all appointed by the President. It is only Parliament that is not at the mercy of the President, as our stay here is dependent on the people who elected us to hold the executive accountable. The independent panel report merely states there may be violations to the Constitution. The impeachment committee may agree with the submissions of the President, and the case will be closed, unless, of course, the President has got something to hide. The only rational resolution Parliament can take is to have the impeachment committee. So all of the things the President is raising in a wrong forum, which is the Constitutional Court, can be dealt with here in Parliament. The Parliament commissioned a panel of experts. These experts concluded that Parliament may investigate the matter further. How can Parliament reject a report from a panel it mandated to look into the matter? A rejection of the report means Parliament is violating its constitutional mandate of oversight and accountability. Parliament can't shield the President who is elected to take Parliament and MPs to court for doing what the Constitution requires of us. The President is attempting to escape accountability by prematurely taking a non-binding report to court. Mr. Ramaphosa can't want to be a president, yet he is against being held accountable. The President is actually undermining the judiciary. How does he trust the current justices in the Constitutional Court, yet is undermining the wisdom of the former Chief Justice Ngcobo? If the President and his supporters believe he's innocent and has nothing to hide, why is he fighting against a process that would clear his name? Members who refuse a resolution to establish the impeachment committee are actually violating their oath of office, which we saw to be loyal to the Republic. As members who took an oath to be faithful to the Republic, let's vote to adopt this report and establish the impeachment committee. Eyokugqibela, ANC ndanisizela yazi. You are made to defend into engayaziyo. You know nothing about Phala, akho kwamali ezekuni, but you are made to defend into engayaziyo. Vote in support of your accountability. Vote in support of oversight. Thank you.
Thank you, Honorable Member. I now invite the Honorable Heron.
Thank you, Madam Speaker. Madam Speaker, today the National Assembly finds itself at a crossroads. It's an opportunity to break away from the culture of impunity that has eroded this House over recent decades and show that Parliament can indeed perform its job in holding the executive to account. Or it could fall again into its old habits. If Parliament were today to bring an abrupt end to this impeachment process, it would fly in the face of everything that this administration has preached of renewal and constitutionalism. South Africa needs leaders who are morally, ethically, and legally unimpeachable. No person is above the law, and the rules adopted to give effect to Section 89 of the Constitution must take their course. That being said, good respects the right of the President to take the independent panel's report on review. Indeed, we share the President's reservations that there are various potential legal irregularities in the panel's work and the report it has produced. To impeach a sitting president, is an extraordinary constitutional act with significant social, political, and economic consequences. It requires a flawless legal process, unswayed by populism, opportunism, or party factional interests. It would be unfair and unreasonable to haul a sitting president before an impeachment committee while these legal questions remain unanswered. And this constitutional process would benefit from clear precedent set by the Constitutional Court on the legal questions raised. The situation is therefore a complex one, but the solution, Madam Speaker, is simple. Parliament should today resolve, in principle, that the Section 89 process must proceed, but the commencement of the impeachment committee should be deferred pending the outcome of the President's review. If the President's review fails, the impeachment committee process must proceed. If his review is upheld, the need for an impeachment committee falls away. Based on the report that we have in front of us today, it would be wholly irrational of the National Assembly to vote to kill off the impeachment process until such time as it has been set aside by a competent court. Equally, it would be irrational of Parliament to proceed to stage 2 of the Section 89 process before finality is reached on the outcomes in stage 1. Good will today move for a resolution that achieves this sensible balance. Two binary options are neither sensible, practical, nor potentially are lawful. Thank you.
I thank you, Honorable Member. Honorable Imam, Honorable Sheikh Imam.
Thank you, Honorable Speaker. Honorable Speaker, what we have is the panel report. And I think what is not in question is that the President has a case to answer. Now, I don't think we can actually doubt that. However, we at the same time cannot overlook the fact that there's an application before the Court to review the findings of this particular panel. Now, I think one of the things we are forgetting here, and I want to say particularly to the ANC, whatever happens in your party affects the entire country. The hate that exists in your party is impacting negatively on the entire 60 million people in this country. You are not only destroying yourself, but you are destroying this entire nation. Yes, it's true that many people want the President out, and for different reasons too. There's no doubt about it. Some for their own selfish reasons, others for his position, others for avoiding prison or orange overalls. But the fact of the matter is this, that what we have before us is a report, and that report must be adopted here today. What we will not agree with, however, I want to reiterate, is the impeachment process until that review application is finalized before a court of law. You cannot accept a report, adopt a report and implement its findings. At the same time, in this case, the President is questioning the findings in that report. Now, let us also say this. We repeatedly say everybody is equal before the law. So let us also treat the President equally. It's his constitutional right to take the matter on review, whether we like it or not. And I know it's not going to satisfy all of us. But unfortunately, according to the Constitution, that is the right and prerogative of the President in this particular case to take this on review. And that is what he is doing. What we believe is happening today, this could have been delayed pending the outcome of that review. All that is happening today, we are wasting millions of rands, and that is where it's eventually going to go to. If we adopt this report and insist we want to implement the findings, all that is going to happen, the President will go to court and interdict this proceedings, and it will come to a standstill. So while we will support the adoption of this report, we don't believe that this process should continue until the review application is finalized before a court of law. I thank you.
Thank you, Honorable Sheikh. The Honorable the Minister of Justice and Correctional Services.
Thank you very much, Honorable Speaker. We are here to debate the contents of the report and not to character assassinate the individuals who compiled the report. We will differ with them with respect. The President has exercised his rights to take the report on review. The opposition parties that are criticizing him for going to court, they go to court daily in this parliament on parliamentary matters. The president, like any South African, has a right to exercise his rights. The opposition, they must also respect that right. Accountability in this house means that we must be able to debate the report. And this is the founding of the Nkandla matter, the economic freedom fighters versus the President of the Republic. It did not say that we must not scrutinize the report. The report says that we must debate, we must engage, and decide whether we are adopting or we are rejecting the report. And that is what we are doing here as Parliament. We are holding the President accountable through this debate. It is not true that by rejecting the report, we are not holding the President accountable. The debate itself is that process of accountability. And that's the reason it was envisaged in terms of the rules that we will either reject or adopt. Even the judgment in Nkandla said that the Parliament will then debate, consider, deliberate, reject, or accept the report. That is what we are going to do. As the ANC, we do not agree with the adoption of the report for the following reasons that I'm going to state. If my colleagues on the left can be patient, I will come with them very slowly. In terms of the rules of Parliament, in terms of these rules that Parliament has adopted, in terms of 129 GB, we can only commence the impeachment process if sufficient evidence exists. Does sufficient evidence exist? In paragraph 80 of the report itself, the panel says it did not have sufficient evidence. There are various institutions that are still to conclude investigations, including Honorable Zungula, the Office of the Public Protector, mandated by the Executive Members Ethics Act to be the only institution to deal with members of the executive issues of their own personal remuneration. The Public Protector and these other 8 institutions have not finalized their investigation. This panel could have said we are going to wait for these findings. If they felt that they don't have the power, they don't have the time, like Zondo did, they could have requested Parliament to extend like they did once. Zondo requested many times until we got tired, but we still respected his because he wanted to produce a quality report. This panel could have also done the same. They did once to the Speaker and they were granted. If they still needed further information, we could not be sitting here doubting the process of the panel, its content and its outcomes. And there is one clear demonstrable example in the panel's report. They cite a Media 24 report, News 24 report of the 6th of September, because they were given by Honorable Zungula and members of Parliament, which was not responded to. And they say this Mr. Hazin does not exist and it's not clear how the money came into the country. On the 8th of September, News 24 published a report confirming the existence of the same person. But the panel says because of the rules, they had to ignore what is in the public domain. The report of the panel still says they doubt if this person exists. But on the 8th of September, before the report was released, News 24 confirmed this person exists. They confirmed that there was this process that was undertaken. And very recently, Sky News, just by the scratching of the surface, confirmed the existence of this person. How do we then adopt this report that did not conclude to get sufficient evidence to start the process to impeach a sitting president? The panel's report has set the bar too low to impeach a sitting president. They compare their report and the process that they undertook with the report of the Public Protector. They say in the Public Protector, in their own words, the panel, they say that in the Public Protector's report, they contrast the work that was done in paragraph 72. They say with the Public Protector, they were required to get what is prima facie evidence. They say in contrast to this, they are expected to get what is sufficient evidence. But what the panel does, they conclude that no, this thing is the same. Both prima facie and insufficient evidence is the same. It cannot be the same. Sufficient evidence, it's a higher standard than prima facie. And that's why, even when you go into the Constitution, it speaks about the removal of the public protector. When it speaks about the president, it speaks about the impeachment of the president. The standard is higher on sufficient evidence. The evidence must be there, it must be concrete. There must be no doubt that this evidence is here and is sufficient to commence this process of the impeachment process. We do not have that sufficient evidence. We do not have grounds to proceed with this debate, with the process to impeach a sitting president. Therefore, my friends from the opposition, I've got very good bad news for you. We will not support this report because it does not have what the rule says it must do. And I want to ask from the opposition, are you going to agree for your members to vote against the adoption of the report? Can Mr. Steenhuisen free your members to vote, because we have now convinced them that there is no sufficient evidence to impeach the president. We now know, Honorable Zungula, free your other members. They must not proceed because there is no sufficient evidence. There is no reason for your members to proceed because there is no sufficient evidence. What is being said and used here is just to blackmail the ANC. That the ANC, it does not want its members. The ANC has always been a constitutional organization, an organization that respects the constitution of this country. Like all members of the ANC, we are here debating because of the constitution. We are here to hold the president to account because of the constitution. We are here to hold all members of the executive ourselves because of the constitution. We respect it. That's why we are here. We are not running away from the debate. If the president wanted to run away from the debate, he would have also interdicted the debate. But the president just took the matter on review to show that he has got grounds. He does not agree with the report. But he does not stop this parliament from debating. He says this parliament must continue, it must debate, it must hold the president to account. And that is what we are doing. There is nothing untoward. You cannot blackmail us to agree with you that it will only be accountability if it's accepted that there must be an impeachment process. Even if there is no impeachment process, it is still accountability. Accountability is the work that we are doing here to scrutinize the report, to scrutinize everything, and we are here saying, in fact and in law, the report cannot stand. Thank you very much. We do not support the report.
I thank you. Honorable Jafta.
Thank you, Honorable Speaker. In the course of this debate, we will extensively cite the jurisprudence of the Constitutional Court dealing with the executive accountability. We will support this motion on principle based on our commitment to protect and promote constitutional democracy. That is our default position, nothing else, Honorable Chief Whip. Parliament's independence must be understood against its broad constitutional role, which requires it to maintain effective oversight over the executive. This is important because in order to safeguard public resources from abuse and plunder, executive power must independently be checked. This independence is grounded in the Constitution, which requires the Assembly, I quote, to represent the people and to ensure government by the people under the Constitution, close quote. When there is an impeachment motion against a sitting president, the Assembly must carry the wishes of the people without fail. Given the office that the president occupies, described by the Constitutional Court in the EFF case as, I quote, the highest calling in the land, close quote. the Assembly members must be able to freely vote on any motion involving the President, Honorable Speaker. The court went further to say the nation pins its hopes on the President to steer the country in the right direction, accelerate our journey towards a peaceful, just and prosperous destination. Honorable members, the Constitution is what must guide the President. He takes an oath of office to obey its tenor. We were told by the Supreme Court of Appeal in 1999 in Patricia DeLille versus the Speaker of the National Assembly that no president, however formidable be his reputation or scholarship, can perform any act which is not sanctioned by the Constitution. From a purely constitutional stand of view, the President cannot bypass the Constitution and its limits in the course of performing his functions. Honorable Speaker, our position on this motion is therefore informed by this rich jurisprudence. Accordingly, evidence must be led and facts sift through to establish the veracity of the claims made in the panel's report.
Thank you, Honorable Member. Thank you. Thank you. The next speaker, Honorable Matisha.
Honorable Speaker, thank you very much. The panel's mandate was to, in quote, determine whether there is a basis to initiate impeachment proceedings against the President, unquote. Now, in its report, the panel says there is no basis. The panel based its conclusion on what it says are loopholes, inter alia. One, the absence of both written and oral evidence. Two, that in some instances where there is written information, such was not written by members but by other people. Three, absence of enough time to collate all information required by the panel to emerge with what one could refer to as the empirical evidence. Now, to quote a few so-called loopholes, in paragraph 80, the panel says, quote, "We are concerned that we have not been given all the information that is available on Phala issue." It further goes on to say, "We believe that the truth of what really happened lies beneath unanswered questions that are foreshadowed by what we are told from the information before us. We neither have the tools nor the power to excavate beneath the information that we have been provided with to uncover the answers to the unanswered questions." Now, the panel's conclusion in paragraph 8.3 says, quote unquote, "The President rightly criticized the evidence of Mr. Fraser's statement as hearsay, in particular the information from undisclosed sources. We are mindful of the dangers of hearsay and caution to be applied in approaching such evidence." Now, that is what is there in the report. Now, in other words, the panel rejects the authenticity of all information presented to the panel by Mr. Fraser. This means that the uncontested conclusion that the panel only used hearsay
Order,
there is a
honorable
problem
members,
here.
Please.
Okay.
Order.
Now, I must say that it is unfortunate that the panel failed to ascertain whether Rules 3.1 of Members Ethics Act, 34.1 of PRICA, which could have without doubt given the panel the differences between the common law criminal offenses like theft, housebreaking versus corruption by president. The panel failed to respond to that question. The panel depended on the media, and I think that has been reported. I propose that we apply both legal and ethical routes so that we can depend on expertise and independence. Parliament must make sure that we are able to go there so that that which we arrive at and with is something that can be able to be taken forward. Thank you very much.
Thank you, Honorable Member. I now invite the Honorable Nyotso to take the floor.
Speaker, this matter is cut and dried. Speaker, we are debating recommendations of the independent panel of judges that says in summary that the leader of the ruling party is truant and irresponsible and that he must be probed even further. We in the PAC agree that the state president must face investigation into the Phala Phala game farm shoddy business. It is scandalous. A whole state president not able to explain himself while disabuses the machinery of the state for his personal gain. He definitely needs to be probed. We do not have to jump to conclusions. However, the ladder of inference so far makes it difficult to us to avoid looking at the moral scruples of the governing party and its entire leadership. They have certainly lost the aura and gravitas of leading the people. The Tsotsis element have long taken over in the governing party. The thieves rule the roost. It is even questionable whether they have been in the liberation movement to fight for the restoration of human dignity and total freedom to a colonized African people. The Africanist pioneers, the founders of the PAC, saw this coming when you adopted the Freedom Charter in Kliptown. The inference we are able to draw from this is that their unscrupulous leaders only think about their stomachs and meaningless pleasure-seeking activities. This probe should not sidetrack us from the collapsing economy and dysfunctional state-owned enterprise under their watch. They face a long indictment list as we go to the voting stations in 2024. That is where the masses of the people will say their say. Azania deserves better.
Thank you very much, Honorable Member. The next speaker is Honorable M.G.E. Hendricks.
I just want to say that the ANC is Al Jamaa light. Chief Albert Lutuli's 10 political commandments, graciously explained by Dr. Pali Lohola at the recent 16th Memorial Lecture, reminds honourable members of this House of Parliament its true cause, that is the liberation of its people, to lead its people with honesty, integrity, without any greed for personal gain and any theft, but to pave the way for a better life for all, to establish a roadmap for peace and stability for the new generation, and not to trample on the graves of those who made the ultimate sacrifice with their lives. Thus, President Ramaphosa come close to these aspirations, is why Al Jamaa has mixed feelings. The Phala Phala report is merely a preliminary inquiry that has allegations of 3 or 4 political parties, that has no evidentiary muster. The panel's recommendation comes nowhere to a finding that there was a gross violation of the Constitution to merit impeachment. Al Jamaa feels that the report must just be noted. The media has created a sensational narrative, and it is time for them to sober up. In 2019, on the basis of one man, one vote, the African National Congress, which is now Al-Jamaah, won the right to govern. The ANC gave the right to their branches to elect an NEC who recommends a president. The 12 political parties in parliament are not branches of the African National Congress or substitutes, and the efforts today must certainly be moot. If President Ramaphosa is the nominee of the ANC branches, then certainly the parliamentary processes to continue to give the nation closure. The nation must wait for the findings of the National Prosecuting Authority, the Reserve Bank, and others to see that justice is done. Also, the dereliction of duty by the country's intelligence chief must be firmly dealt with. I told President Ramaphosa when he met with leaders of political parties when the July insurrection broke, the country is not in safe hands. In the absence of any findings of gross violation of the Constitution by the Concord, the no charges against him, President Ramaphosa, if elected by the branch of the ANC, must continue as Chief Albert Lutuli in his wisdom directed. Let us vote the way Chief Albert Lutuli would have wished, not along party lines, but in terms of our oath of office. Another question is whether keeping $1 million in the furniture compartment is a gross violation of the Constitution. This was common cause before the panel, and they did not find gross violation of the Constitution. An inquiry relating to a motion proposing an inquiry in terms of Section 89 of the Constitution is not supported by Al-Jamaah. Al-Jamaah, however, thanks the panel for defining the allegations.
Honorable.
The report has no other value. Thank you very much.
Thank you, Honorable Hendricks. The next speaker is the Honorable, the Chief Whip of the Opposition.
Speaker, much has been said about this vote today. And much will be said here about why this process, despite the fact that it was commissioned by this very House and its members, should be ignored. However, not much will be said about what this vote is not about. This vote is not about impeaching the president. This vote is not about the highly contested ANC presidential race. This vote is not about where the political lines are drawn and who's politically aligned to who. This vote is about accountability. This vote is about the Constitution that we all swore to uphold and the commitment that we made to South Africans to be lawmakers who respect the rules of this House and, by extension, the people who sent us here. It is a vote to complete a process that we collectively embarked on, showcasing that it does not matter whether you're the president of the country or an ordinary citizen, the laws of this country apply to us all impartially. It is a vote to afford the president an opportunity to have the truth uncovered, an opportunity an innocent person would grab with both hands. To deliberately make this vote about the president and not about the principle of fairness and the rule of law is simply dishonest. It is undoubtable that crimes were committed on the president's Phala Phala farm and state resources were abused. It is also evident that this did not begin and end with the president, and that an entire network of government players and ministers are possibly implicated, especially judging by Minister Lamula's very spirited defense of the president this afternoon. To vote against the recommendations of this panel is to send a strong message to the people of South Africa that you only have to be politically connected to be insulated from accountability. This is not the first time a choice like this has been faced by this House. Many of you were here and voted to disregard the Nkandla ad hoc report, which detailed the abuse of state resources by the former president of the ANC, Jacob Zuma. You did so shamelessly. You did so with no regard of the massive responsibility you've been entrusted with. You did so in spite of the fact that South Africans deserved more from you. You chose party over country, and today you will make the same choice again. You will choose a cover-up over accountability. You will once again go down in history as the governing party that broke Parliament. This is a big moment that will be recorded in history so that years from now, people will read about the disdain with which you treated this House. Those who will vote for what is right and not what is politically expedient today will be voting to restore the credibility of this House. And one day, when your children ask you what you did in big moments of our democracy, may you be courageous enough then to admit that you stood firmly on the wrong side of history.
I thank you, Honorable Member. I now invite the Honorable Q. Kumutile Janji.
Thank you, Honorable Speaker. Let me recognize our number 2, Deputy President Mabuza. The African National Congress has been entrusted with the people's mandate of leading the nation. This is a duty of honor, and we accord the revered commitment to ensure that people's power realizes their creation of an equitable and just society. Since the beginning of the 6th administration, strengthening the state institutions and combating corruption are some of the ANC's critical priorities to improve the state capability to bring about socio-economic transformation. Since the release of the preliminary inquiry report by the independent panel on the removal of the president, our nation has been confronted by political and economic risk, which have led to uncertainty. Just a few factual facts of the journey and the attempts that have been made. We should recognize that since the beginning of this 6th Parliament, a motion of no confidence to the president was proposed by the ATM since 2019. It was resuscitated this year, and they withdrew it due to the court not agreeing with their position on a secret ballot due to their self-created urgency. The EFF would have repeatedly intended to do the same. The Democratic Alliance has tabled a motion of no confidence on the cabinet, including the president, which was considered in March 2022, and the House did not support that. The Democratic Alliance went further to sponsor a motion for the establishment of the ad hoc committee on Phala theft, itself not supported. Recently, this unprincipled alliance of opposition parties, whose sole objective is to remove the ANC, have also resolved to table a motion of no confidence on the president based on this preliminary report. So, fellow South Africans, as we speak to you today, as the ANC, we are confronted with an opposition that seeks the ANC's demise at all costs through crook and hook to precipitate the nation to the instability of coalitions that are experienced in major cities. These hypocrites from these opposition parties do not consider the stability of the country and the recognition of the people's will, which has given the ANC the mandate to lead the nation. What this unprincipled opposition parties also undermines and does, they do not have confidence in an impeachment process which requires a 2/3 majority to remove the president. They do so by making a call for a motion of no confidence whilst considering the independent panel report, on which Parliament has to decide whether to establish an impeachment committee. The opposition parties also try to subcontract members of the ANC to be, and they want to be their shop steward, to say you need a secret ballot. In fact, even that secret ballot, it looks like it depends on the hope that members of the ANC will vote for them. Opposition parties caucuses on positions and matters, and so does the ANC. The ANC advances decisions after assessing the balance of evidence, and members of parliament exercise their rights and according to their oath and constitutional obligations. A few things from the panel report. The independent panel makes some critical observations in the report. Firstly, the independent panel did not know whether South African Reserve Bank had concluded its investigation. If so, and the outcome of that investigation. They didn't know. Secondly, the independent panel recognized that the public protector is conducting an investigation into the matter. Thirdly, the South African Police Service is investigating the conduct of presidential protection services, and the panel did not know whether these investigations have since been completed, and other institutions such as the South African Revenue Services, the Financial Intelligence Center, as well as Home Affairs. Fourthly, and more significantly, the panel was not made aware of progress, if any, that the Hawks have made with regard to their investigations into these allegations by Mr. Arthur Fraser against the president. And in all of that, we are asked to support a report that is so full of doubt. The panel itself is doubtful about its own work. In paragraph 48 of the report, the panel explains that the panel is required to consider, as Honorable Lamola would have indicated, preliminary inquiry relating to a motion and thereafter make a recommendation whether sufficient evidence exists to show that the president committed any of the three grounds in the Constitution. To determine prima facie evidence, the consideration made is whether any complainant or applicant furnishes proof of which, if uncontested or uncontradicted, will stand to be accepted as truth and factual. The panel in the report is uncertain about the substance of the evidence it received from these three parties, EFF, UTF, and ATM, and the president. It is unsure whether the president has committed any acts that constitute a ground for removal because there's no sufficient evidence. That's from the panel. On the issue of money laundering, Honorable Malema, this opposition argues that there are issues of money laundering. Money laundering is regulated by the Prevention of Organized Crime Act, the POCA Act, which defines that money laundering at Section 4 is any person who knows or ought reasonably to have known that property is or forms part of the proceeds of unlawful activities. This would be a false and misleading assertion to argue that the president committed money laundering, as the panel report also does not know the origins of the money found on the president's farm. There is no evidence or prima facie evidence that the source of money is the proceeds of unlawful activities. That is why Rules 129P concerning recommendations focus on recommendations not being binding. This means if the panel recommended an impeachment committee, the Assembly reserves the right not to adopt the report or to adopt the report. This is stated in Rule 129P1 that the Assembly will make the final and binding decision relating to any matter dealt with in this rule. And any recommendations made by the independent panel or the impeachment committee or any decision by the Speaker in terms of this rule is not final and binding on the Assembly. The ANC does not support this report because the independent panel itself was not convinced that it had sufficient evidence. But having considered the information placed before it, which is insufficient, it disclosed that the president may have committed some violations. The position of the ANC is not an arbitrary position. It is a product of consideration of balance of evidence and the multiple factors the independent panel raises. The review of the president on this panel report is also informed by the testing of the basis of the recommendations of the panel report. Our disapproval of this report is not to stop accountability by the president. Instead, the president should continue to be accountable to Parliament. The independent panel does confirm that they have not tested the validity of the evidence as alleged in affidavit of Mr. Fraser. The panel also declared detailed limitations imposed on them by the process, yet their conclusions are not congruent or consistent with the information that they had. An impeachment process of the president removal must be based on substantive prima facie evidence. We call on all South Africans not to be conjured up by the media and opposition hype. It's moments like these that we test our ability as a nation to navigate these complexities. These hypocrites think that they have a firm grip on the ANC and its life. The panel report fell short of minimum threshold to lead us into an impeachment. The issue here is the test in the rules is sufficient evidence, not prima facie evidence. In other words, the test to be applied is much higher than prima facie, as Honorable Lamula would have indicated. No matter how many times you repeat these accusations, they will not stick or become true because of their repetition. It is therefore important that, Honorable Speaker, we go back to the drawing boards and fix some of the defects that we have in our rules. I thank you.
Thank you, Honorable Member. I thank you, Honorable Member. Honorable Member, that concludes the debate on the independent panel report. I will now put the question. Are there any objections to the Section 89(1) inquiry? Is there a point of order? Honorable Heron? Yes, you have the floor.
Thank you, Madam Speaker. Madam Speaker, as I indicated, we wish to propose an alternate resolution in terms of Rule 121(1) of the Rules of Order. May I present it?
Yes, you may proceed.
Thank you, Madam Speaker. The alternate recommendation or resolution that we're proposing, that the National Assembly resolves that given that the President has applied to the Constitutional Court to review and set aside the report of the independent panel, that the establishment and appointment of an impeachment committee is deferred in terms of Rule 129(k)(2), pending the outcome of the President's review, and 2, if the President's review fails, to the extent that any part of the report is upheld, which found that the criteria in Rule 129(g)(1)(b) were met, then the impeachment committee must be established and appointed to commence the Section 89(1) inquiry. Thank you.
I thank you, Honorable Heron. Honorable members, Rule 123 provides that any motion or every motion requires notice, except those draft resolutions specifically exempted by Rule 123, which includes a motion for the postponement or discharge of any order of the day. And therefore, Honorable Heron, essentially you are moving that the establishment and appointment of the impeachment committee should be deferred pending the outcome of the President's review application at the Constitutional Court. A motion for the postponement or discharge of an order, right, of the day in terms of Rule 123(1)(c) should have been done right at the beginning of the proceedings. As you did not move this motion prior to us debating the order, it can only be assumed that your proposal was in fact intended not as a postponement motion, but an amendment to the question that has now been put. This amendment is equally out of order in terms of Rule 121(i). In the instance the question before the House is that Section 89, order. In the instance that the question before the House is that Section 89 inquiry be proceeded with, your proposed resolution, however, asks for the House to decide on two substantive matters. A resolution to postpone the matter, and at the same time another resolution to proceed to an inquiry contingent on a future. As yet, uncertain outcome of a process that is outside the ambit of the National Assembly. The Assembly cannot relinquish its own mandated responsibility in this manner. I rule, Honorable Heron. Honorable members, we now proceed Honorable members, I proceed. I will now put the question: are there any objections to the Section 891 inquiry being proceeded with on the basis of the independent panel report and the matter being referred to the impeachment committee in terms of Rule 1291? If there are any objections, I now put the question. Those in favor of S89-1 inquiry being proceeded with and the matter being referred to the impeachment committee will say yea, and those against the Section 89 inquiry being proceeded with will say no. I think order. I think the noes have it. Honorable Kwahube.
Speaker, the DA would like to call for a division, please.
Honorable members, the DA has called for a division. And therefore, we will now, we will now proceed with the division, and the bells will be rung for 10 minutes.